Invite Mr. Shenkman to the stage. Carey Shenkman is an attorney, litigator, and author, specializing in human rights and constitutional law. He works with numerous organizations, including the Center for Constitutional Rights. Mr. Shenkman is also an advisor to Colombia's Global Freedom of Expression campaign. Carey Shenkman will speak of the implications for freedom of the press by the government's use of the Espionage Act to indict Mr. Assange.
Thank you very much. I want to say it's an honor to be present here with such a compelling program and very, very necessary. I do want to make one quick disclosure that I did work on Julian's case for the late Michael Ratner for several years before his passing. Thank you. And as part of that case, we actually brought a successful lawsuit before the United Nations, which some of you might be aware of. We filed a petition before the UN Working Group on Arbitrary Detention, where we were able to successfully argue that the situation in the Ecuadorian embassy amounted to arbitrary detention under international law. And I think something that is really important to point out about that specific case was that we had international law, international body recognized under the UN, issued an opinion saying that Julian won, that this was illegal conduct. And the UK and the US completely ignored it.
Yep.
And I think that should really set the precedent for how we should expect any extradition proceedings to proceed, anything potentially before the European Court of Human Rights, and any supposed debate that we might have about respect for the rule of law or for international legal instruments or treaties. But today, what I really want to talk to you about is another topic that's been close to me over the past several years, which is the Espionage Act. And for the past 5 years, I've been co-authoring a book on the Espionage Act, specifically on its political history and the way that it's been used to specifically attempt to control information and target political movements. And one thing that I wanted to address is something that I think is a big assumption, and sadly, I think a way that many of us have fallen to the US government's marketing about the Espionage Act, is that somehow the Espionage Act is being misused. That no, this is a law about prosecuting spies. This is an espionage law, and it is being wrongly misappropriated to prosecute whistleblowers. It's being wrongly used against Julian Assange. But in fact, the Espionage Act is being used exactly how it was intended to be used. It is not an espionage law. And we need to stop calling it an espionage law. It is an information control law. And to see that, you have to look no further than the actual legislative history and the political history of this law, which was passed just a few months after US entry into World War I. And in fact, in his speech, advocating for U.S. entry into the war, which is a little ironic because Woodrow Wilson ran on the platform of keeping the U.S. out of war. Wilson said ominously, if there should be disloyalty, it will be dealt with a firm hand of stern repression. And when the Espionage Act was proposed, and I'll add that the Wilson administration and its DOJ actually wanted to have a law like the British Official Secrets Act, which goes further than the Espionage Act to impose strict liability for any disclosure of classified information. Wilson basically looked at that law and said, hey, that looks great, let's have something like this here. But when the Espionage Act was proposed, Wilson said that disloyal Americans, quote, had sacrificed their right to civil liberties. Among the first 2,000 prosecutions under the Espionage Act were prosecutions for speech and opinion in opposition to the war.
Wow.
In fact, many of these prosecutions were for publication. One little wrinkle is that the case against Julian is not the first case under the Espionage Act for publication. In fact, the early Supreme Court cases, the very first cases leading to our First Amendment doctrine, were Espionage Act cases involving the distribution of leaflets. The idea of the lonely pamphleteer who has as much a right to exercise First Amendment rights as the big media institutions like the New York Times and Washington Post. And defendants were often prosecuted for spreading such leaflets. Another context for the original passage of the Espionage Act is the fact that a year later, in 1918, it was paired with the Sedition Act, the first such Sedition Act passed in this country since 1798, which we all might remember from U.S. history. And that act punished, quote, disloyal, profane, scurrilous, or abusive language about war or the system and government. While that Sedition Act was ultimately repealed, the focus and omen of the Espionage Act remained, and that served as a guiding principle for individuals such as J. Edgar Hoover, whose career started in the investigation of Espionage Act cases. It also propelled the rise of the ACLU, which was involved in the early defense of Espionage Act defendants. The Espionage Act was famously used to prosecute the Wobblies, including William Big Bill Haywood, as well as 100 other labor leaders in a mass political trial. Interestingly, with Haywood, he ended up leaving the US and being exiled none else than Moscow. An interesting place to spend the rest of his days, and 100 years later, we can think of another Espionage Act defendant currently exiled in Moscow. Also, Eugene Debs, a socialist presidential candidate, faced 10 years imprisonment under the Espionage Act for what was considered the most famous protest speech of his time, and that was the Canton, Ohio speech. He received nearly 1 million votes from prison. So let's keep this in mind when we think about the nature of this prosecution and whether or not this is really a legal case or a political case. In fact, the Espionage Act has been highly contentious since its passage. One of the prominent narratives that you'll hear about the Espionage Act today, especially from the Justice Department, is that this is simply a violation of law, that this is, you look at the black letter of the law, we're simply enforcing and applying the laws, and this was a clear violation of law. But when you look from bipartisan criticism across the board for the last century, there's been unanimous confusion and criticism of this law. You have in 1979, the CIA's own general counsel, I can read to you, Tony Lapham was his name. He testified before Congress that the espionage was, quote, so vague and opaque as to be virtually worthless. And also, likely that the very obscurity of these laws serves to deter perfectly legitimate expression and debate. 2 Columbia law professors in 1973, following the unsuccessful prosecution of Daniel Ellsberg, those were Harold Edgar and Benno Schmidt Jr., their law review article, it's over 100 pages long, it's considered widely the authoritative legislative analysis of the Espionage Act. Their conclusion is that the law is, quote, in many respects incomprehensible. They also add that it poses the greatest threat to the acquisition and publication of defense information by reporters and newspapers. In fact, in 1917, one of the opponents of the Espionage Act, Senator William E. Borah of Idaho, called it unconstitutional, un-American, unwise, and unnecessary, adding that no one can foresee all the evils to flow from it.
Wow.
That was over 100 years ago. I'd just like to finish by debunking another myth about the Espionage Act, that there's a possibility for a fair trial under this law. And we saw this narrative a lot with Snowden. In fact, something that Barack Obama liked to say a lot was that he needs to come back and face the music. He needs to come back and face trial. But under the Espionage Act, there is no opportunity for a defense. The revelation of war crimes, the revelation of corruption, of any misconduct is completely irrelevant, is literally irrelevant. In fact, the Justice Department's position right now is that by offering such a defense is essentially an admission of guilt, because the element of the offense is the disclosure of information. We can see the current administration's position on this issue by looking at the prosecution of Daniel Hale, who is a former NSA analyst who's allegedly an intercept source of Jeremy Scales' drone papers. I'm quoting from their papers in that case. They said, quote, the defense likely will want to argue that, even if the defendant engaged in the conduct alleged, he had good reasons to leak the documents at issue and is being unfairly prosecuted under criminal statutes that carry significant penalties. Any such arguments, however, would be entirely improper. The defendant may wish for his criminal trial to become a forum on something other than his guilt, but those debates cannot and do not inform the core questions in this case: whether the defendant illegally retained and transferred the documents he stole. That is the state of this law, the Espionage Act. There will be no opportunity for a defense in the public interest. And in this respect, the United States is an outlier. It's the only country on earth that has a law governing the disclosure of secret information that doesn't offer proportionality defense, and such a failure of this defense is a violation of international law and international standards.
Yeah.
I wish that I could leave that on a more positive note, but I'm happy to address more. We have some limited time. There's quite a lot of rich history for the Espionage Act. One thing that I will leave on, actually, I think in dealing with the topic of intersectionality and the use of the Espionage Act, there's a very little known episode under FDR's administration where J. Edgar Hoover and FDR actually tried to target the black press under the Espionage Act for their opposition to the war effort. And in fact, J. Edgar Hoover was sending monthly memos to the Attorney General Francis Biddle saying, why won't you prosecute this publication under the Espionage Act? We can imagine similar things are happening today and will only continue to happen in light of this case.